Good morning, good afternoon, good evening. And here we are again with an exceptional presentation about the 1995 Constitution, an inquiry into whether it's a paradox, contradiction, or political fraud by Attorney Mubiru Musoke. He has been an exceptional fighter for freedom and justice. He attended the Moshi conference that paved the way to the removal of Idi Amin before we went through the painful experience of letting a river run through our fingers without taking even a drop. He has continued to enlighten us in respect to the application of law to the cause of justice, to building a robust foundation for a dignified, peaceful, and prosperous society, a learning society. He has a focus and attention to detail that teases out the nuances, revealing an outcome that's both beautiful and elegant. That screams joy of learning, joy of knowledge, and joy of values and principles. An approach that leaves you with greater thirst for knowledge than when you started. What a pleasure to introduce him to you this morning, Mr. Mubiru Musoke.
Thank you, Mr. Chairman. I hope you can hear me. In this first conversation on whether the Constitution of Uganda is a paradox, a contradiction, or political fraud, I will briefly lay out the work of the Constitutional Commission that drafted that Constitution, the 1995 Constitution, and incorporated the two basic principles in the Constitution of Uganda: the supremacy of the Constitution and the sovereignty of the people. These two principles are important, but they are not originally of the work of Ugandans. They are not definitely the result of the Uganda Constitutional Commission work. I will also talk about briefly how the Constitution of Uganda creates a duty to defend the 1995 Constitution, and yet the same Constitution provides in Article 2 that the people are sovereign. So how can a sovereign be, a duty be imposed on a sovereign to defend the Constitution and even to fight and die for it? That is puzzling to me. But in this first conversation, let me first inform you how the Constitutional Commission operated and how it came to the decisions and the draft of the 1995 Constitution. The Uganda Constitutional Commission statute was enacted in 1988. Under the statute, the Constitutional Commission was required to seek the views of the public in order to determine the ideas Ugandans had regarding the enactment of the new constitution for Uganda. The Uganda Constitutional Commission used three main methods to construct the architecture and the fabric of the new constitution. First, the Constitutional Commission solicited Ugandans to make submissions expressing their views for the new proposed constitution. In this respect, the Uganda Constitutional Commission received submissions from individuals, from groups, from local government bodies and organizations. Second, the Uganda Constitutional Commission organized seminars and workshops nationwide at all sub-county levels, at different institutions and different organizations. Third method by the Uganda Constitutional Commission was to seek the views of the people, including schools, which they organized essay competitions about writing this constitution. The belief at the time was that a wide consultation of Ugandans in the making of the new constitution would produce the best constitution imaginable. The 1995 constitution, however, has turned out to be an obstacle to democratization of Uganda. The original version of the 1995 constitution has provisions which contradicted each other and in fact violated the protection of fundamental constitutional rights of Ugandans. Article 3, for example, is inconsistent with the basic fundamental principles proclaiming the sovereignty of the people. This issue will be discussed later on. In this conversation with the people of Uganda, we try to explain the contradictions and inconsistency of the provisions of the 1995 Constitution. Some of the contradictions, for example, between Articles 20 and 269 are so fundamental that they amount to political fraud. They include Articles 69 to Article 6974, which created the movement system. The movement system was incompatible with the enjoyment of the inherent rights as declared by Article 20. The real puzzle is to explain what went wrong and the politics that facilitated the inconsistencies, the contradictions, and the paradoxes that appear in the 1995 Constitution. Some of the underlying beliefs of the makers of the 1995 Constitution were so naive that they thought that the quality of the provisions of the 1995 Constitution would be determined by the extent of the people's participation in making that constitution. The myth that involving the people in making the constitution necessarily makes it efficacious and legitimate or even rational will be exposed and explained in this conversation. Uganda Constitutional Commission was appointed in 1988. to initiate the process of enacting the 1995 Constitution. Under the mandate of the Uganda Constitutional Commission, the mandate of the commission was very broad. The statute required the commission to study and review the Constitution with a view to making proposals for the enactment of the 1995 Constitution. And the statute made it clear. It gave the mandate consisted of 8 points. The first one was to guarantee the national independence and the territorial integrity and the sovereignty of Uganda. The second was to establish a free and democratic system of government that will guarantee the fundamental rights and freedoms of the people of Uganda. And third, to create viable political institutions that would ensure maximum consensus and orderly succession to government. And fourth, recognize and demarcate district divisions of responsibility among state organs of the executive, the legislature, and the judiciary, and create viable checks and balances between them. And the fifth point or requirement or duty of the commission was to endeavor to develop a system of government that ensures people's participation in the governance of their country. And the sixth, endeavor to develop a democratic, free, and fair electoral system that will ensure people's representation in the legislature and other levels of government. And 7, to establish and uphold the principle of public accountability by holders of public offices and political posts. And lastly, guarantee the independence of the judiciary. And as you know, because of corruption, none of these responsibilities has ever matured. The Constitutional Commission was also instructed to formulate and structure a draft constitution that would form the basis for the country's new constitution. That was probably one of the worst recommendation by the given under the statute. I will explain that later on. In order to accomplish its tasks, the Uganda Constitutional Commission was required under the statute to, quote, seek the views of the general public through the holding of public meetings and debates, seminars, workshops, and other forms of collecting public views, and quote, it is clear that, excuse me for 1 minute, I have a problem here which I have to show before I come. Okay, I think my computer was not behaving right, but the issue is how the Constitution was made and the obligations the duties the Constitutional Commission had to observe in making this constitution. One would have thought that the idea of making a fraudulent constitution would not be acceptable. But it turns out that, in fact, it turned out to be the case. The Constitutional Commission was also required to stimulate public discussions and awareness of constitutional issues, unquote. The Constitutional Commission had the power even to summon any person to appear before it and to produce any document or thing that may be considered relevant to the functions of the commission. So you can see that they had very broad powers, they had a very wide mandate, and they had everything. They even had the resources to travel throughout the country to meet people at a sub-county level, all the sub-county levels in Uganda. So one would have thought that the constitution arising from such a process would be the best, to say the least. In order to explain the universal forces which have shaped and continue to shape not only the democratization process, but also simultaneously have determined the content of the modern constitutions, we have to go beyond the work of the Uganda Constitutional Commission. This knowledge is to be found in history, in a constitutional theory, and in social theory. History, for example, helps us to define democracy. A definition of democracy has varied as new concepts such as the rule of law, the supremacy of the constitution, and sovereignty of the people have emerged and become part of the definition of democracy. Constitutional theory is a narrower field of social theory. Many of the premises of classical social theories, such as the capital theory, the labor theory, the culture theory, and the social contract theories, have been rendered invalid, at least in part, and some have outlived their usefulness as the concepts of they represented were historically nullified. The best example is the capital theory. The concept of democracy on which communism was founded is now practically dead, at least in Russia, where it was applied first. The labor theory on which colonial policies were of racial separation were rationalized and justified have and even the anthropologists and the colonial administrators and the apartheid believers justified in South Africa seems to be in intensive care unit, if not dead yet. The culture theory formulated by Max Weber has been recently revived and invigorated in explaining the conditions for economic development and democratization in new developing states and countries. The pulse of the capital theory is still ticking in China, but it's not clear how long it will continue to tick. The contract theory, which gained a firm foothold in constitutional theory and was originally written by Rousseau, for over 2 centuries, it seems to be in its sunset era. The new politicized programmatic social theory formulated in the 1980s to focus on explaining democratization has yet to prove efficacious or even valid in tackling complex contemporary problems of democratization. It is therefore obvious, the reason why I'm mentioning all this, if not necessary, to restate these theories as we define the concept of democracy with a view to exposing where they have become obsolete and not applicable to the dynamic social reality of modern society. We shall do this by offering a definition of democracy based on its historical and substantive transformation over time. According to the chairman of the Uganda Constitutional Commission, Benjamin Joseph Odochi, quote, "The exercise of collecting the views through memoranda and oral interviews was very successful," unquote. Apparently, the chairman of the Constitutional Commission was referring to the enormous volume of the evidence the commission collected rather than the quality of the evidence gathered by the commission. The Uganda Constitutional Commission received 3,392 memoranda from individuals and groups. It received 12,377 memoranda from the resistance councils, that is RC1, RC2, RC3, and RC5. Out of the 38 districts, only 2 districts did not submit any memoranda. From a regional perspective, the RCs in the central region submitted a total of 4,425 memoranda. The eastern region submitted 2,736 memoranda, and the northern region submitted 786 memoranda. And finally, the western region submitted 4,381 memoranda. The Constitutional Commission received 3,392 memoranda from individuals and groups. The total amount of submissions of memoranda from the whole country was 25,547 memoranda. Now I'm reciting these figures to show you that they actually had a lot of input and whether or not we can judge the quality from this input which they got. The Constitutional Commission statute required the Constitutional Commission to create public awareness about the constitutional issues and to seek the views of the public through meetings, debates, seminars, workshops, and any other form of collecting public views. Obviously, to the best of my knowledge, the Constitutional Commission never educated the people as to what democracy means. In fact, I believe that the greatest failure of the Constitutional Commission was that it never defined what the word democracy means. The failure of the Commission to give the people a precise definition of democracy led to combining two systems of government in one constitution, namely the movement system and the multi-party system. That fact explains why the movement system was presented as a democratic system of government, which in fact it was not. Under the 1988 statute, the Commission had a duty to, quote, establish a free and democratic system of government that will guarantee the fundamental rights and freedoms of the people of Uganda, unquote. Instead, the Commission recommended the establishment of two alternative political systems in the same constitution, the multi-party system and the movement system. The existence of the movement system required the prohibition of the protection of human rights protected under Article 29 of the Constitution, because the protection of those fundamental rights was inconsistent with the existence of the movement system. Only one political system could be allowed to exist at a time. This paradox and contradiction could not only make sense if you do not have a valid definition of democracy. As we shall point out below, even if the Supreme Court acquiesced into this contradiction when it decided to interpret the Constitution as one whole in order to avoid invalidating the contradiction provisions under Articles 20, 29, and 269. Clearly, the Supreme Court was not interested in an accurate definition of democracy. Otherwise, it could not have turned a blind eye to a legal contradiction. And yet, in order to aggravate the contradictions in the 1995 Constitution, a constitution which was declared to be the supreme law of Uganda, which in turn declared the people to be sovereign under Article 1 of the 1995 Constitution, went forward to institutionalize the movement system in the 1995 Constitution. How could the people be sovereign when their fundamental rights, human rights, described under Article 20 as inherent or inalienable, were denied protection by the same Constitution, which is the supreme law of Uganda? Well, let us look at the concept of supremacy of the Constitution. The doctrine of supremacy of the Constitution was discovered and proclaimed by the judicial branch of United States, the Supreme Court, by Chief Justice John Marshall, when he interpreted the US Constitution in a case called Marbury versus Madison. The US Constitution enacted in 1787 was the first constitution in the world to clearly articulate and apply the principle of separation of powers as understood in modern constitutional theory. Although the principle of separation of powers had gradually evolved under the English system, the political system of England, beginning in the 14th century, when executive and legislative powers were gradually transferred from the monarchy to elected officials in cabinet and parliament. The principle of separation of powers was not spelled out in clear terms until the American Constitution was enacted in 1787. Under the US Constitution, the executive, legislative, and judicial powers are clearly demarcated. The US Constitution, the US Constitution in Article 1 declares that all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of the Senate and the House of Representatives. And Article 2 provides that the executive power shall be vested in the President of the United States. And Article 3 stipulates that the judicial power of the United States shall be vested in the Supreme Court and in other courts, subordinate courts, legislated by created by the legislature. In the US, it was the full interpretation and the application of the 3 articles of US Constitution quoted above that by Chief Justice Marshall in the case of Marbury, I've just pointed out, Marbury versus Madison in 1803, that the Chief Justice declared the principle of supremacy of the Constitution for the first time in constitutional history. Chief Justice Marshall deduced the principle of supremacy of the Constitution from the fact that the Constitution was written and derived from a clear separation of powers in the Constitution. Supremacy of the Constitution, as it emerged later on during the democratization process, is an important constitutional principle designed to protect and enforce the enforcement of the sovereignty of the people. It is the judgment of Chief Justice Marshall elaborated on these important characteristics underlying the concept of the supremacy of the Constitution. Marshall pointed out that for example, let me actually quote him, it will be better. This original and supreme will organizes the government and assigns different departments their respective powers. It may either stop here or establish certain limits on the transcended by those departments. So what he was saying that was that the separation of powers and the written constitution created the supremacy of the constitution, and the supremacy of the constitution produced the sovereignty of the people, because courts can nullify a law that is inconsistent with the constitution. So the legislature is not the supreme one. The people become supreme for that reason, because they are the ones who elect the leaders, and the courts can strike down the legislation which is inconsistent with the constitution. This is important because Article 1 of the 1995 Constitution talks about sovereignty of the people. And Article 2 of 1995 Constitution talks about the supremacy of the Constitution, that the Constitution is supreme. But how much substance is in these provisions of the Constitution of 1995? The fact is that the elaborate explanation of the function of the court in interpreting the law, especially the Constitution, will become even more relevant and revealing when we look at the courts in Uganda, how they interpreted Article 20, 39, 29, and 269 in this so-called theory of looking at these contradictory provisions as one war, in order not to strike them down. This is where the paradox is. By the way, before I leave this point, let me point out that there was a very lively debate between William Jefferson and Chief Justice Marshall, the Chief Justice of at the time the Chief Justice made this decision, the supremacy of the Constitution. William Jefferson thought that because the Constitution did not spell out clearly who will interpret it and who will not interpret it, therefore it means that the Supreme Court did not have the power to do so. Well, surprisingly, Jefferson, the brilliant politician and the author of the Declaration of Independence in 1776, had very little understanding of the principle of rule of law and how ultimately it was logically connected with the principle of separation of powers. Jefferson, for example, argued that allowing the judiciary to be the sole interpreter of the Constitution, or for that matter, the other laws, would make the judiciary a despotic institution or branch of government. Of course, he was wrong, and the Chief Justice Marshall was right. Throughout the world, you can count all the constitutions. They have these provisions of supremacy of the Constitution, sovereignty of the people. It came from that decision by Justice Marshall in 1803, and that's very important. There is no question that over 200 years after Chief Justice Marshall handed down the decision in Marbury versus Madison, he decisively won the debate between him and Thomas Jefferson. The evidence is in the extent of the impact of Chief Justice's judgment on the other political systems throughout the world. The principle of supremacy of the Constitution, born in a decision of Marbury versus Madison, has been universally embraced and has spread throughout the whole world. Uh, it, it is now one of the fundamental constitutional principles that has been adopted by all democratic political systems. In fact, the principle of supremacy of the Constitution was enacted in all independent African constitutions in the 1960s. For example, Article 1 of the 1962 Constitution of Uganda provided that this constitution is the supreme law of Uganda. If any other law is inconsistent with this constitution shall prevail, and the other law shall, to the extent of inconsistency, be void. Now, that formulation, which we have in our independent constitution, 1962, was exactly the formulation which Chief Justice Marshall of the United States made in a case of Marbury versus Madison. So I'm trying to emphasize here why it is important to understand these principles. Now, on the sovereignty of the people can only be sovereign when certain sociological, political, and legal conditions exist. Sovereignty of the people does not exist in a political vacuum. As we have observed all over Africa, a mere constitutional provision or legal stipulation that the people are sovereign does not make the people sociologically sovereign. Sovereignty of the people only exists where democracy and the rule of law prevail. The people cannot be sovereign if their rights to liberty, to freedom of expression, security, and the right to freely protest bad government policies, or where the results of the elections are rigged. Sovereignty of the people legally refers to the ultimate source of political authority in the state. Under a dictatorship, for example, political authority is concentrated in the hands of a dictator, regardless of the legal stipulations of the Constitution, as the 1995 Constitution does in Uganda. It does not matter what the Constitution says. The people cannot be sovereign when their constitutional rights are ruthlessly suppressed by a dictator. Uganda under Milton Obote, under Idi Amin, under Yoweri Kaguta Museveni are very good examples of this contradiction. All constitutions of Uganda, beginning with the independence constitution of 1960, were supreme law of Uganda. And by implication, Ugandans were supposed to be sovereign, as Chief Justice Marshall of US had correctly stated. However, the Ugandans are not sovereign. As a matter of fact, let me read you the Article 1. All power belongs to the people, who shall exercise their sovereignty in accordance with this Constitution. Second, without limiting the effect of Clause 1 of this article, all authority in the state emanates from the people of Uganda, and the people shall be governed through their will and consent. 3, all the power and authority of government and its organs derive from this Constitution, which is in turn derives its authority from the people who consent to be governed in accordance with this Constitution. The people shall express their will and consent on who shall govern them and how they will be governed through regular, free, and fair elections of their representatives or through referenda. Now, that's Article 1. Does it make sense to you? Does it mean that really Ugandans are sovereign? When elections are rigged, sovereignty of the people is stolen. The man who is rigging the elections is stealing sovereignty of the people. And so these are empty stipulations in the Constitution, which really mean nothing when you look at the political reality. The history of the transformation of the principle of sovereignty, which started as a title to the monarch, and eventually democratization shifted the sovereignty from the monarch to government, to the state, and eventually to the people. This historical process of democratization clearly explains the process that ultimately is responsible for sociologically transferring sovereignty to the people through democratization. But that can't happen unless all these other conditions exist, like the rule of law, unless the elections are not stolen, unless there is security and the people are free to express themselves. So we have a big problem right there. Just because just stipulating, some people think that when you put something in a constitution, you've done something great, but it doesn't mean that. It doesn't mean a thing if, for example, the dictator determines what to do and when to do it. You cannot talk about sovereignty. Let us now talk about the sovereignty and the duty to defend the 1995 Constitution. This is the real topic I want to talk about. If sovereignty confers the ultimate political authority on the people in a democratic political system, which Uganda is not, of course, where does Article 3 of the 1995 Constitution derive the legal and moral authority to impose a duty on all Ugandans to defend the 1995 Constitution at all times? All political actions must be presumed to be discretionary and guided by the beliefs of the individuals involved. This is the essence of the purpose and purpose of protecting liberty. First, let us deal with the incongruous provision of Article 3, paragraph 4, which says all citizens of Uganda shall have the right and duty at all times, A, to defend this Constitution, in particular, to resist any person or group of persons seeking to overthrow the established constitutional order, and B, to do all in their power to restore the constitution after it has been suspended, overthrown, abrogated, or amended contrary to its provisions. By including this provision in Chapter 1 of the 1995 Constitution, which is the most important chapter of the Constitution of Uganda, the makers of the 1995 Constitution imposed the duty on all Ugandans who are fully recognized as sovereign by the same Constitution to defend the 1995 Constitution at all costs. By doing so, the makers of the 1995 Constitution did two contradictory things. First and foremost, the makers of the 1995 Constitution institutionalized dictatorship, since the 1995 Constitution could not theoretically be overthrown. And if it was, then there was a duty on part of the people to restore, to fight, and restore that constitution. If you can, I'm assuming you can believe all that. By including this provision in the Constitution of 1995, the legislators or the makers of the Constitution were, fussing around. They were. I can't imagine even a person like Odochi, who is a judge, sitting down and endorsing this kind of nonsense to be included in the Constitution, and to impose a duty on all citizens of Uganda to fight to protect the 1995 Constitution. First of all, the 1995 Constitution, as you know, is a unitary constitution. It creates a unitary regime, but some people want the federal system. So how can you tell them that they have to sacrifice their lives defending this constitution? Does it make sense? Were the authors of this constitution drunk or stupid or what? I mean, had they read any history to understand what they were doing, enacting? I doubt that. Constitutional obligations in modern constitutional theory are always subjective. They are ideological and they are political in nature. They are not sanctioned by or derived from sacred holy scriptures, which the 1995 Constitution is pretending to be. In fact, they derive their legitimacy from a specific free human democratic process. That's why we believe that Article 3 robs all the political liberty of the people of Uganda from them, because the people have, they have obligation. They have an inherent or inalienable human rights under Article 20, but at the same time, then we are told that the Ugandans, the same Ugandans who have these inalienable rights, have an obligation to fight and preserve the 1995 Constitution forever, and keep it alive. And even if it is overthrown, when it is restored, those who overthrew it are going to be punished. Does Museveni believe in all this? I think he does, because he is a dictator And really, they made this constitution for Museveni, not for the people of Uganda. And it should not be allowed to stand. By enacting Article 3, the makers of the 1995 Constitution advanced at least 3 irreconcilable legal propositions. First, since under Article 20, human rights are inherent or inalienable and not granted by the state, Ugandans, as a sovereign authority under the Constitution, cannot be forced to love, let alone protect and defend any provision of the 1995 Constitution. To impose a duty to the sovereign people at all times to defend the 1995 Constitution is in effect an explicit denial of the sovereignty of the people of Uganda in solving their political problems. Second, Article 3 presumes that Ugandan society is not subject to the laws of history, which make social change inevitable and desirable under oppressive political circumstances. These laws of history are responsible for transforming political systems in the US, in France, in Russia, and more recently in South Africa. When society changes, its values change, and those values are accordingly transformed in order to be compatible with the new social political circumstances. But such change of values cannot occur peacefully if the law prohibits, the law here is the Constitution, prohibits the people to freely initiate such change through peaceful democratic process. We should remember that when in South Africa, between 1960 and 1990, under the apartheid regime, where peaceful change was originally ruthlessly prohibited by apartheid law, change came to South Africa anyway, violently, through a liberation war led by the brave Nelson Mandela. We also have to remember that the 1995 Constitution is unitary, which cannot be amended and transformed into a federal constitution, which the majority of Ugandans want today. Therefore, it's futile to start talking about Article 3 to impose obligations on Mubirumusoke to fight for. How can I fight? In fact, I do the opposite. I fight to overthrow it, not to preserve it. And I have that right. It's an inalienable right or inherent right. We should also remember that dictators love unitary political systems because unitary political systems are conducive to centralized political authority. Unitary political systems allow dictators to control the people using the concentrated dictatorial executive power. It is ironical, however, that in his manifesto for 2021 elections, Museveni has already indicated that when elected, his primary objective will be to achieve the East African Federation. As we shall point out below, Museveni has not believe in a democracy or federalism in Uganda. He, however, strongly believes in holding political power. When Museveni went to the bush to fight Obote's regime in 1981, he did not do so in order to achieve democracy for Ugandans. Museveni's political behavior and the fact that he has engineered 2 constitutional amendments to allow him to stay in power uh, forever is sufficient to prove our point, the point we are making here. Museveni's sole goal to fight the Bush War was to get and control political power in Uganda. And it was enacted in the 1995 Constitution. Museveni's experience in the Bush War, ironically, actually spelled out in Article 3, which purports to make the 1995 Constitution last forever. Museveni believes that preserving the 1995 Constitution would secure his dream of a life presidency for him. Lastly, the makers of the 1995 Constitution purported to have a power they do not possess, namely, the power of the Almighty in constitutional making. When God gave Moses the 10 Commandments, God presumed the infallibility of man and the eternity of the 10 Commandments. The 10 Commandments cannot be amended by human beings because the human beings are subject to God's scriptures without any questions asked. Unlike the 10 Commandments, human beings are subject to God's scriptures. And therefore, the 10 Commandments given to Moses by God on Mount Sinai is not equivalent to the 1995 Constitution. And so it is an abuse, in fact, abuse of power, abuse of political authority to pretend that you can make a constitution which is transcendent, is equivalent to the 10 Commandments given by God to Moses, which I believe, anyway, it cannot be compared. The two cannot be compared. For the same reasons articulated above, Article 3 does not make sense in a democratic political system. Article 3 provides that the Constitution, quote, shall not lose its force and effect, even where its observance is interrupted by a government established by force of arms, and in any case, as soon as the people recover their liberty, its observance shall be re-established. And all those who have taken part in any rebellion or other activities which resulted in the interruption of the observance shall be tried in accordance with this Constitution and other laws consistent with it. Museveni, I laugh at you. We cannot be subjected to this kind of constitutional mockery, and it say that there is a constitution that is eternal, as if it is the 10 Commandments given by God to Moses. So let us look briefly at the paradoxes, the contradictions, and the fraud in particular of the 1995 Constitution. No constitution I'm aware of has contradicted itself more than the 1995 Constitution. These contradictions are the key to discover why it was enacted in the first place. Ironically, much of the legitimacy of the 1995 Constitution derived from the fact that ordinary people participated in its making. I started off by reciting the memoranda which the Constitutional Commission gathered from throughout Uganda, over 25,000 memoranda. That did not, these memoranda did not make the Constitution the result legitimate, later alone efficacious, or even for that matter, it's something that can endure for forever, because the 1995 Constitution is not equivalent to the 10 Commandments given to Moses on Mount Sinai. It's just probably here I may even support Amin. He said a constitution is karatas. It is karatas peki. It is just a piece of paper, and for him, of course, for Amin, he didn't realize that norms are not just simply karatas, because in Britain, for example, they don't have a constitution, but they have norms that govern their political behavior. So here we don't have norms. We have a prescription, a legal prescription, which is supposed intended to last forever, but I doubt that it will last forever. I will do my best to make sure that this constitution does not last forever. In any case, I must also point out that this Article 3 of the 1995 Constitution was copied word by word from Article 136 of the Mexican Constitution of 1917. So we know this. It didn't come from the memoranda, 25,000 memoranda, which Odochi collected throughout Uganda. It came from the heads of the Constitutional Commission, as for example, just to remind you, Article 20 declares that the fundamental rights and freedoms of the individual are inherent and not granted by the state. Now, these rights are not granted by the state. Now, Museveni is telling us we have to fight and to preserve 1995 Constitution. This is funny, more than funny, it is stupid. And then the Article 29 says that every person shall have the right to freedom of speech and expression, freedom of thought and conscience, freedom to practice any religion and manifest such practice as he wishes, freedom to assemble and demonstrate together with others. Museveni instead is prohibiting under the Public Order Management Act the people from demonstrating. Freedom of association. Now, all these rights, they are in the 1995 Constitution, and they are supposed to be grounded into Article 20, which says the fundamental rights and freedoms of the individual are inherent and not granted by the state. So where does Museveni and his people, where do they get the power to tell Mubirumusoke that he cannot overthrow the 1995 Constitution? I can't understand this. If I have the right which are inherent, are not, they are given to me by God, then this constitution cannot take out. Now the paradox here was Article 269. It provided, just to let you know what its content was, that on the commencement of this constitution, and until Parliament makes laws regulating and the activities of the political organizations in accordance with Article 73 of the Constitution, political activities may continue except opening and operating branch offices of a political party, holding delegates conferences of a political party, holding public rallies of a political party, sponsoring or offering a platform to or in any way campaigning for or against a candidate for any public elections by a political party, carrying on any activities that may interfere with the movement system of government. So this is where I started saying that it was ridiculous to put two systems in one constitution, the multi-party system and the movement system. Now, the movement system, in order to operate, they enacted this Article 269, which prohibited all the rights which were guaranteed by Article 29, which these rights were described by Article 20 as inherent, inalienable. They are not granted by the state. Are these paradoxes? Is this confusion, stupidity, or what? I mean, it doesn't make sense to me. And then you tell me that the 1995, I have to defend it, and it is a unitary, it's a unitary system. I want federal. I can't die for unitary system. I can die for federal, but not for a unitary system. So you see these paradoxes, these contradictions, all of them in one document. And to make things worse is that the Constitutional Commission itself contributed to this mess. For example, let me quote the Constitutional Commission. The Commission has therefore interpreted the wish of the majority of the Ugandan people to be that of wanting both political systems to be established in the new constitution and left to the sovereignty of the people, or to periodically decide through a national referendum which of the two systems they prefer at any particular time of their political, taking into account their political development. Such a freedom of choice, the Commission wrote in their report, based upon the sovereignty of the people, will serve as a powerful safeguard of democracy and will greatly influence the the manner in which such political system operates, and will prevent the dangerous polarization of views on the crucial issue. The Commission discussed fully the implications of such regular referenda and on so vital an issue. It came to the conclusion that since democracy always grows, the people of Uganda would, at some future time of their democratic development, clearly express through a referendum whether they want one or of the two systems to be permanently adopted. At that time, the commission concluded the regular referendum on the political system would come to an end through the expressed people's consensus on the issue. And they didn't stop there. Actually, the Constitutional Commission did recommend the enactment of Article 269 because they said the party activities which are defined in the new constitution as incompatible with the movement system should remain suspended during the period the movement system is in operation. If the procedures in the preceding paragraphs result in provisions for the movement system being included in the final constitution adopted by the Constituent Assembly, then after 5 years, a national referendum will be held to decide by simple majority whether people wish the movement system to continue or if they want the multi-party system to operate. Now, the hidden secret here is that these people, the commission was saying, oh, if the people vote, when they vote, then that is legitimate. They forgot that Article 20 said these rights are inherent, they are inalienable. Therefore, they cannot be taken away by majority vote. That's exactly what human rights are for. If you say that everything will depend on the majority, then you won't have protection of human rights. The majority will always vote their political interests, and that's exactly what the Bill of Rights is for. It cannot be subject to majority will. Otherwise, these inherent, inalienable rights are put in danger, and they were put in danger in Uganda under the 1995 Constitution because the Constitutional Commission was stupid enough to think that the majority vote can determine which right you can enjoy and which right you cannot enjoy. That's the issue. That's even a dumb person can see that. And I'm sorry to call them dumb, but that's what I see here. And I think the point has been made. These contradictions, to make things worse, were endorsed by the Supreme Court when they made a decision. Remember those cases Paul Osemogere litigated? There are many of them. One was Dr. Ranyarare and then Olumu. They went to court, and the Supreme Court said, we interpret all these provisions as one whole. And when they did that, they conspired to do exactly what they should not have done. We don't have a chief justice like Chief Justice Marshall of the United States in the 1800s, who established the sovereignty of the people and supremacy of the Constitution, which are now universal. So here we have even a Supreme Court interpreting the law and the Constitution in such a way as to preserve these contradictions. So what else do you need? Well, I will stop here for this time, and I will come back with a second conversation in which I will discuss the content of modern constitutions. How did the content of modern constitution arise? And I will also give a definition of democracy, which the Constitutional Commission did not give, because that would have saved them a lot of trouble and the contradictions if they had defined democracy to mean A, B, C, C, and so on. Then they would not have incorporated two systems, the movement system and the multi-party system, into one constitution, when one of them, the movement system, was the superior one and could subordinate the rights of the people. So when I come back in another conversation, I will discuss all these issues, but even more important, I will talk about political communication in society. Why do we need demonstrations? Why do we have protests? Why do we have riots? Why do we have rebellions or mutiny and war in the last resort? When we understand why these things happen, when there is a failure of communication between the people and the government, then you have all this. You have war, you have civil disobedience, you have mutiny, you have rebellion, you have riots, protests, demonstrations. SG's favorite word is defiance, but defiance also falls under many of these categories. But anyway, thank you for listening to this conversation. Hopefully you will tune in again and listen to me in a conversation dealing with the content of a modern constitution, definition of democracy, and political communication in a society.
Thank you very much, Attorney Mubiru Musoke, for an exceptionally enlightening presentation. What a gem of a legal mind. Thank you very much.
Let me also join the chairman of Uganda Democratic Federation in extending my thanks to Mr. Mubiru Musoke. Thank you for breaking it down and analyzing the 1995 Constitution and pointing out the articles that have got contradictions, making the whole Constitution sound like a fraud. I hope that Ugandans will make time to listen to the presentation and learn as we go forward. Thank you for pointing out the for those rights. Thank you so much for the rights that the government cannot violate under any circumstances. That was clearly pointed out. And as a supporter of the all-inclusive federal system and all those Ugandans that support an all-inclusive federal system, they really feel silenced or suffocated, and they can't come out. I think we have a few questions. We have some time, maybe 5 minutes for some questions I see in the chat from the attendees. I am going to ask the co-host, Ms. Twexize, to read some of the questions.
Okay.
Thank you, host, and thank you, Mr. Mbirumusoke, for a wonderful presentation. And our first question is, can the participant asked if you can please enlighten more about the collection of memorandum, the intensity of federal system in Uganda, and let me see that I can't.
Thank you very much. The federal system. Okay.
Somebody please mute.
Yeah. Sure. Thank you for the question. The collection of memoranda in Uganda, as I pointed out, there were over 25,000. What does that mean? That was a big volume of memoranda. The question is, does the volume and the quality match? Whether the volume of the collection of memoranda reflected the quality. The quality of the I made my presentation in my office, and now there is a phone which is and I can't turn it off. But anyway, the point is very well taken about this memorandum. What I want people to understand is that the fact that a lot of people contributed memoranda did not actually mean that there was a quality, a lot of the high quality of the material that was necessary to make a constitution of Uganda. As you know, the constitution of the United States is a very small document, very small, and yet it covers almost everything that there is to cover. It has had about 33 amendments, but even if you include all the amendments to the original document, you cannot compare the quality of the Constitution of the United States, which is less than 10 pages when you print it, to the quality of that of Uganda, which is over 130 pages. So I think we have to learn to distinguish between quantity and quality. And when I come back to talk about the content of a modern constitution, that issue I will make sure that it is made clarified. Quality and quantity are not the same thing. In Uganda, we had a lot of quantity of memoranda, but they didn't mean much. As a matter of fact, let me say, the Article 3, which was borrowed from the Mexican Constitution, could not have been drafted in one of these memoranda, the 25,000 memoranda. That I think then explains where our problem is. Second, you talked about federal. The issue of federal is very, very important. And the theme of federal, as you know, I touched it just on the fringes. A federal system is very important in that it gives the people at the lower local level power to govern themselves. Those of you who have lived here in the United States, you know very well that the states govern themselves, and the federal government is separate from them. It is in charge of foreign affairs and federal issues. However, when it comes to local affairs, let us, for example, focus on COVID problem. The COVID problem has shown how important local leaders are important. In New York, they had a very, very intensive exercise in fighting COVID, and they almost wiped it out. But those who did not, like in Georgia and in Florida, in Texas, they have a different result. And I think we have to learn from that. Federal can be a double-edged sword. It recognizes the right of the people to govern themselves in a local area, but at the same time also it can be dangerous in the sense that if you have bad leaders, you can end up messing up the entire state, the rights of the people. But by the way, for the Black people or the African Americans, this is a very good experience. Racism, for example, persisted here in the United States. It persisted much longer because it was handled by state governments. And the state governments were full of people who were discriminating, who were racist. And as a result, African Americans couldn't even vote, legally vote, until the Civil Rights Act of 1965. So, but we have to, that teaches us something about federal. For example, there are many versions of federalism. There is a Canadian version, there is an American version, there is a Swiss version, there is an Indian version, Australian version. So this is where we have to study these systems, comprehend them, understand them, and then take out what is good out of all those and create a new one which is excellent, which is both preserves the rights of the people at the lower level, but at the same time is like the Swiss. I like the Swiss model very, very, very much. I've studied it, and it's probably one of the best political systems you can have. But anyway, that's I'm saying federal here, and there is no reason why I shouldn't say it. But in any case, we have to study all these other systems and see where they fail. And this concept of sovereignty of the people came up in the Canadian case. The Canadian case when Quebec wanted to secede, and the Supreme Court of Canada ruled that sovereignty is indivisible. Because it is indivisible, one state, a federal state, cannot unilaterally withdraw from the union, the federal system. And as a result, they had to negotiate. If they want really to go and leave the federal system, by the way, that also gives you a point to when you are designing your system, whether you are going to include a provision of how to exit the federal system. If there are going to be a right or how do you define it? When does a state justify the exit from the federal system? So I think I've rambled a lot, but on the issue of collection of the memoranda in Uganda, I think what we learn from it is that quantity is not quality. They had a lot of memoranda in Uganda. They did not necessarily produce the best constitution possible. Federalism, sure. I'm going to fight Museveni until I die because I want federal. I don't want the 1995 constitution. And you can't tell me that I will die fighting for it, or when it is overthrown, it will nevertheless come back. From where? It will come back from hell and start imposing duties on people to oppressive repression. Anyway, that's my response to those two issues on the memoranda and the federal system.
Thank you so much, Mr. Mbilmusoke. They also wanted to know why Justice Odoki ignored it anyway.
Who wanted to nullify?
The participant who asked the question wanted to know what went wrong that Justice Odoki ignored that.
Oh, okay. Now I get it. The Odoki, by the way, I happened to have been in Uganda in 1990, and I met him, and he entertained me and gave me some of the copies of all the constitutions and all that. And I thought he was a very good man, who, by the way, he is an excellent speaker of Uganda. Whenever they went out in the villages, he was speaking in Uganda to these people. So he went to school in Budo, and I think he learned Uganda. He speaks it perfectly. So you could also kumugaya. But anyway, the problem with this particular constitutional commission which they set up, although I think I started by enumerating what it was required to do under the 1988 statute. Unfortunately, the problem that arose during the collection was to misunderstand what democracy means. That they wouldn't have put the movement system together with the multi-party system in one constitution if they knew really what democracy means. The second issue is that they did not understand what inalienable rights means. You can't vote on inalienable rights. Otherwise, they mean nothing. A Bill of Rights is always protected. It's not for majority to decide which right is good for Mubiru and which one is not good for Mubiru. Once it is a human right, you can't put it to a vote. For example, I may give you a bad example. Of course, I give bad examples in order for people to understand exactly what I'm saying. Supposing in Uganda a movement arose and says the women should not be voting in the elections, and the movement that movement was led by a woman, and men also followed. And supposing 96% approve in a referendum that women should not vote, should not have a vote. Democratically, the majority has, yes, passed that issue, but they are passing it on a an issue that should never be voted upon, whether or not women should vote or not. That should not happen. And I think that's where the biggest problem arose under the Uganda Constitutional Commission, because they applied democracy, or if I wouldn't even call it democracy, they applied the majority vote to the determination of the rights of the people. And that's why they are contradictory. Article 20 says the rights are inherent, they are given, the people are born with it, and the state can't take it. And then they turn around and they say, put it to a vote. Should we have a movement system or should we have a multi-party system? Right there, you are trying to vote to determine whether or not people have a right of association, of assembly, of vote, to elect their people and so on. And you are putting it to a majority vote, which is wrong. It shouldn't be put to a majority vote. And when I come back, hopefully I will have an opportunity. That is the issue I'm going to emphasize, the issue of the content of the modern constitution, and the idea of inalienable rights. You can't vote on those, and these are the entrenched in the constitution. You can't just say, because the majority want this, therefore that's what will be done. That's the wrong way when you are talking about human rights. Thank you. I don't know whether I've enlightened any point or just made it worse.
Thank you, Attorney. You sure did enlighten that point. It was a brilliant answer. And now we'll go to our next question, and that's Mr. Mwangavatuka. Please unmute yourself and ask your question.
Thank you so much. And I'd like to join the others in thanking Mr. Mubiru Musoke for an enlightening conversation that we've had today, as we've had the privilege to. The discussing the Constitution has always been a very extensive and sometimes complex matter. I definitely agree with the fraud and the paradox that you've talked about. I need to hear, maybe not now, but maybe in the future, more about the sovereignty of the people. And you've kind of touched on this point in your very last comment, because this is my worry. Article 1 has always been used by the NRM government to lure people into referenda or any kind of voting, maybe including yes in parliament, when they propose provisions that benefit only one party, and thus creating a single party system. Now, they're using the argument of the sovereignty of the people, which to a casual observer seems legitimate, that people are being called on to exercise their right. And in your response, I want to hear your thoughts about this very important principle, but which otherwise has been corrupted. And if you could also talk about how we could, moving forward, help to educate our people the difference between the substance of that sovereignty and the procedure of that sovereignty, and making sure that our people understand that democracy and sovereignty, exercising that kind of sovereignty, is not simply something that they are called upon to exercise on the day of the election and electing or making a choice, regardless of the substance of the matter? Thank you.
Okay, thank you very much for that question, which is a very complicated question. You can look at it from a historical perspective, and you can look at from a contemporary.
Mr. Mbiru Musoke, we can't hear you.
He has unmuted. He has muted himself.
Let's give him one more minute and see. Otherwise, it's a big question and he can answer it next time. I would have liked him to touch on it today. Did he unmute himself by mistake? Mr. Mbiru Musoke, you are unmuted, please. We can't hear you.
Mr. Mbiru Musoke, please unmute yourself.
I think with that, if we can't, he probably has some technical problems. I am going to end this presentation. Thank you very much, all participants. Oh, he's back.
Did I unmute finally?
Now you are, yes.
Yes,
Go ahead.
Now you can hear me. Okay. Sovereignty of the people, yeah, that's a very complex. But if you explain it from a historical perspective, I think people can understand it better. Let me begin with the pre-colonial period of Africa. Was there sovereignty of people? The political scientists think that actually democracy came with the after the colonialists came. But what they forget is this concept of sovereignty did exist. Who was sovereign? It was the community. Community was sovereign. In other words, sovereignty defined as the ultimate source of political authority. Who was the ultimate source of political authority? It was the community. In other words, but it made sense. The people were sovereign to the extent that the community was sovereign. By that, for example, you know that ethnic groups were separate. Until the colonialists came, all ethnic groups lived separately by themselves. The Achoris, the Langis, the Baganda, the Bato, the whoever you want to think. In that sense, sovereignty, for example, in Buganda was within the system of Buganda. Was communal, enjoyed from a communal point of view through the Bika, through the Bika had to contribute. I don't know whether you attended the Mutebi's Savasajja's inauguration, because it could teach you a lot that every clan had a function in that inauguration, in that ceremony of the Kabaka becoming the Kabaka. You know, that was, in other words, communal. The community sovereignty there, you can see, resided within the community, and this also you can apply to other ethnic. I'm not saying that every pre-colonial community was sovereign, and where it wasn't, the consequences are clear. For example, in Ankole, the Bahima, who were a minority, were the supreme authority, and the majority who were they were the subjects of they were 90, you know, the Bahima were about 90%. And so the rest of the majority were ruled and very, very, very roughly. Same was true in Rwanda and Burundi. The Hutus were the slaves. In fact, the king always came from the Tutsis, who are the minority. Same with Ankole and Rwanda and Burundi. Now, those did not have, sovereignty was not vested in the people. It was vested in a discriminatory group, which was ruling at that time in Ankole, Bahima, in Rwanda, Tutsis, and in Burundi the same. This also happened in Ethiopia. The so-called Mprogo Yuda, the king, the emperor came from a certain group within the Ethiopian community, and as a result, the sovereignty did not spread over to the entire community. And you know what the consequences have been? These places which I have mentioned, Ankole, Rwanda, Burundi, and Ethiopia, they have not restored their kings. Why? It is not an accident. They have not restored it because sovereignty didn't reside within the community as a whole. It resided into an oppressive minority. And as a result, we can now talk about it. And I think you can even begin to understand why why you can't restore the kingdom of Ankole or Rwanda, Burundi, or Ethiopia, because sovereignty did not spread over into the entire community. It was monopolized by a clique of a minority group. And so when I say in pre-colonial Africa, sovereignty resided in the community, now you understand what I mean. The Baganda as a kingdom, they were sovereign because all the Bika were equal, and there was no discrimination. And you can say that Buganda sovereignty was within the Baganda as a whole because of the Vika and so on. Now, when we come to the modern, this word sovereign has been changing. That's why it is important to define democracy, what it means. Sovereignty has changed. Originally, it meant the monarch. The word sovereign actually meant the king. And the king possessed all the power and all the authority. But during the process of social change and the transformation of these systems, for example, United Kingdom is one of the best examples. The power of the king was reduced by taking away his legislative power, by taking away his executive power and giving it to elected people in parliament and the cabinet. And this took a long time. It started maybe within the 1300s, and And then there was this revolution of 1689, and under that, that consolidated the transfer of power from the king to parliament. And by the time the American Revolution took place, and Jefferson was a brilliant historian as well as a politician. He knew what was going on, and so when he wrote the Declaration that these truths are self-evident. Of course, self-evidence of the truth did not include the women, did not include the black, the slaves were still slaves. They were not part of the sovereignty. However, social change cannot be prevented, and even within the United States, the Civil War of 1960s was fought to free people from slavery. Obviously, a slave could not be part of the sovereignty of the people, and even after the abolition of slavery by the 13th Amendment in 1865, still the Ku Klux Klan, by the way, it was formed here in Georgia, in a very close place from where I live. The Ku Klux Klan came up, and was not, the idea of freedom of the black people, of the African American, was detestable. They couldn't allow it, and so segregation continued. So long as there was segregation, there was no sovereignty. The sovereignty of the people did not include both the black people and the women. The women became sovereign, joined the sovereignty when in the amendment of 1920, the 19th Amendment to the American Constitution, that made women part of the sovereignty. So you can see that these things, the sovereignty didn't mean one thing at all times. It kept on changing. It kept on changing. The blacks couldn't vote, even had no right to vote until 1965. So they couldn't therefore be part of the sovereignty. The sovereignty here means the ultimate source of political authority. If you don't participate in the system, you can't be a source of that. That's what many people, by the way, the racists here, that's what they are resenting, and they are scared. They don't want the other minorities to be a part of the sovereignty. But in any case, it is inevitable, because social change is not, you can't prevent it. It is going always to take place. So where do we stand with the sovereignty? Sovereignty historically has changed from, as I said, from the king to the parliament to the government. And sovereignty has been shifting with the democratization. When the king, let's say in the United Kingdom, when the powers of the king were taken over by the cabinet and the parliament to make laws, sovereignty shifted to the government, to parliament. As a matter of fact, in English constitutional law, parliament is sovereign, and because it can make any law, and it cannot, and the courts cannot nullify any of the laws parliament makes in the UK. So, but that's a different type of sovereignty when you look at it from the sovereignty of United States at this particular point. The sovereignty here means that the people, literally the people, are the ultimate source of political authority. In Africa, as I tried to explain, sovereignty can't exist if you have discrimination, as it was here in the United States, if you have a regime that suppresses the human rights. The rule of law is, in other words, part of preserving and protecting sovereignty of the people. If there is no rule of law, you can forget about sovereignty of the people. The Constitution may proclaim that the people are sovereign. Museveni, in fact, goes around saying the people are sovereign. They are sovereign not when you were stealing their votes, their elections, and they are sovereign when you were terrorizing them. You can't talk about sovereignty in that context. Even if the Constitution says so in Article 1, the reality is different. Political reality is different because the people really are not the real ultimate source of political authority. So I don't know whether the Mukodomi has gotten the point I'm trying to make. It's a very complex one, but probably after thinking about it even more, I will, when I come back, I will elaborate more on it, or even give you better examples to explain what sovereignty really means. It is part and parcel of democracy. That's why the Constitutional Commission messed up. They didn't have a definition of democracy anywhere in their document. If they had defined the democracy, they would not have allowed the movement system, because the movement system is incompatible with the protection of the rights protected under Articles 20 and 29. So that's the move you are experiencing, and I hope the Ugandans wake up and fight this Constitution 1995, which literally it institutionalizes dictatorship, that it can't be, that Constitution is there forever. That's why I gave the example of the 10 Commandments, which God gave to Moses. Those you can't amend because they are given by God. However, the Constitution of Uganda is not a scriptural text. Therefore, we can fight it, we can remove it, we can change it, and we can overthrow it. Thank you for listening.
Hello. Yeah.
Okay.
Thank you very much.
Yeah. Okay.
Thank you so much, Mr. Mbirumsoke, for that wonderful presentation.
You are welcome.
As Ugandans, we now know our rights and how our constitution was rigged. So that's why we need this regime to be changed right now. I also take this opportunity to thank all the attendees and participants, Facebook followers. You've been a great audience. That's all what we had time for, and tune in next time. It will be an ongoing conversation. Thank you so much. And now we beg to close. Thank you.
Thank you.
Thank you so very much.